Record. Okay, can somebody Vanna White this for a second, just so I can key? Just with Brad needs a slide changed. You can take it away, Brad.
Excellent. Good morning, everybody. Hope everybody's well. Looking to go into title searches today and spend a little bit of time, hopefully answering some questions, hopefully introduce you to a few things about titles that you didn't know and reaffirm some things you did know. And we'll get into some best practices and that kind of stuff as well. I got Michelle or whoever else there going to help me with the slides so I don't Parkinson double click us into oblivion and go from there. We'll try and keep it going. Title searches in the province of British Columbia are a critical aspect of understanding real estate transactions, property ownership. It is fundamental to what we do. We're conveying an interest in land, and we really are going to talk mostly about freehold transfers today. Freehold interest in land. We're not going to get too much into leases. We'll touch on it in a couple of instances, but we're going to mostly focus on the freehold interest. Slide, please. What is a title search? What is it commonly used for? This is not a seminar. This is going to be engaged. I want to engage, and I want people to tell me, what is a title search? Anyone?
A search to tell what the charges, covenants, easements are on registered to a property.
Did you hear that, Brad?
Yeah, that's certainly part of it. When are they commonly used?
To verify ownership of a property.
And the description.
Yes. Yeah, it is a snapshot of a title at any given point in time. So it's used predominantly for whether it's being conveyed, bought or sold, or used a lot for lending purposes, banks doing mortgages and what have you. They like to get into the details and make sure that it's a good marketable title. A slide, please. Searching the title is a process used to investigate and confirm the legal ownership and history of a specific piece of real estate. I'd like to touch on the history. We typically do title searches that are a current snapshot, but you can do a historical search on any property and it'll give you all the records back, previous owners and all the information, mortgages that have been discharged, all that kind of information is available. So a lot of times people think it's only available what is current, and that is mostly what we use, but it is absolutely able to go deeper than that. Slide, please. What is the purpose then of a title search?
I can see the answers, so.
Oh, I don't know how that happens. Okay, that's fine.
No, just
I can, because I can see the next slide, but no one else can. That's just why I couldn't answer.
Okay, well, that's fine. Then pick on somebody else there that I can't see. Tracy Gobel.
Oh, Tracy Gobel. Okay.
Yeah, Tracy, I'm calling you out.
All right, thank you for doing that, Brad. Purpose of a title search is to identify the ownership of the property, how the ownership is structured. For example, joint tenancy, tenants in common, and probably also just to identify the property on a number of different levels. Make sure you're dealing with the right property.
Gold star. Awesome.
Yay.
Next slide. The purpose of title search is to ensure the interest in the property being transferred has clear and marketable title. That means there's no legal claims, disputes, or encumbrances, and we'll get into those in more detail, that could affect the buyer's or lender's rights to the property. Next slide, please. Title search helps to confirm that the seller or borrower has a legal right to transfer or use the property as collateral. It identifies the current, and as we learn, you can also see the previous property owner. Slide, please. The search will review any outstanding liens, mortgages, easements, encumbrances, and pending claims on the property. And these things can affect a new owner or lender's rights and obligations. I've had it asked of me, when is it appropriate to obtain these documents? Should we be getting them when we listing them? There's different regions have different, I won't say policies, different practices as to when they do them and what have you. My opinion is you can't list a property accurately unless you know everything that affects the title. So I think it's incumbent on a listing realtor to obtain those documents and review them, and where appropriate, refer them to a lawyer or somebody who's an expert that can decipher some of them, because some of them can be very complicated. And we'll get into a few examples here in a little bit. And the only thing, I know Kelowna, for example, has a policy of not providing non-financials to buyers. And I think that it has to be done regardless of the listing. It's arguable as to whether somebody wants to take the liability of giving the documents to somebody else and them relying on them to be the complete set of documents. Electronic transfer of information has helped quite a bit. It's not quite as risky like the old days. A page gets caught in a photocopier and you're missing a vital part of the land title office document. But we can get into practice standards in a little bit, but that is something that I'd like to address. If you're listing property, you should, to do your job and know what all the interests on title are. It can identify legal issues. It can uncover unpaid property taxes, judgments, builder's liens. The title search helps prevent potential legal disputes in the future, as it uncovers any issues that might affect property's marketability and a new owner's or lender's right. There's lots of situations where a registered owner can have a divorce, and there's something that the Family Law Enforcement Act puts a charge on title. There's different things like that that affect it, and we're going to go into some specific property or titles, and we'll work through that. A marketable title is one that is free from defects and encumbrances, making it easy to sell or transfer the property. Title search helps ensure that the property has marketable title, which is crucial for real estate transactions, including mortgages. Okay, who's going to get a gold star? Where does the title search come from?
Land titles.
It was specifically
LTSA.
the land
LTSA.
title. Yeah, LTSA, Land Title and Survey Authority of British Columbia. And it's their role to keep the records of all titles and surveys for the real estate in British Columbia. What are the common forms of a title search?
What do you mean?
Well, they take different formats. Title is a bit of a misnomer in British Columbia in that, and I'll get into the exception in a moment, but the title search is, a title doesn't really exist. It's an electronic document stored in a government database. And there is no physical deed or title. You watch lots of US old movies and they talk about the deed to the property or the title to the property. And we don't have such a thing in Canada and specifically British Columbia. What we have is the mechanism for taking, like I said at the beginning, a snapshot of the property at a given date and time and reflecting what charges or not or interest in land people have. So the common ones are, the most common one you're gonna talk about is title search print. It's what we pull off online out of LTSA, and it's a snapshot at that date and time of what the property is subject to, and so on. The other one that's very common is a state of title certificate. And that is commonly given to an owner when they either buy or mortgage land, and the lawyers order one to give to the client as part of their closing documents in summary. And it has the exact same information as a normal title search print. It just comes on a fancier paper and all that, and they call it a state of title certificate. So it's same information. Let's go into the next slide, into actually one of the title searches. There's a lot of information that is available to us that a lot of people aren't aware of. For example, at the title that we're looking at right now, it identifies the land district, Kamloops Land Title Office. You could have Victoria or Vancouver as other ones in the province. The title number is really important. It gives you the title number directly translate to the freehold transfer that transferred the property into the current people's name. And it'll include the purchase price on it and so on. It can be advantageous if the property hasn't been marketed or there's not anything coming up online, you can pull the from title number, and that'll be the previous freehold transfer that was registered. And so you can see what they paid for the property. Any questions on that? You can actually order that just like you order an easement or right of way or anything else, and they'll give you an actual copy of the document.
What would be the purpose of that opposed to a PID search?
Well, you would be searching it via PID. What it does is the title search doesn't reliably give you the information about the purchase price and everything else that taxes were paid on.
Gotcha.
So that's the most advantageous. I'll get to it in a minute, but you can do the same thing for like mortgages, and it's way more helpful in mortgages to pull the original mortgage document on occasion, because if you're, especially in a market like we're seeing now, and we have more challenging times for some sellers coming ahead as they renew mortgages and so on, they're going to be concerned, or we should be concerned about their ability to clear title. So you can get a lot of information from most, not all, mortgage Form Bs as to how much it was borrowed, what the interest they're paying, all that kind of stuff. And it's good to know on the buy side, because you can be aggressive and sometimes know what people absolutely need to get out of the property, assuming they've made all their payments and what have you. And it's good for us to know that if we have given them a market evaluation for $500,000 and their mortgage registered on titles for 510, we might have a problem clearing title.
Can we
And-
also do that from the land title office?
Pardon me?
You asked if we can still order that. Yeah. Yes, you can order that.
Yes. Yeah, and it works the exact same way. You take the registration number of the mortgage, and they'll actually give you a printed copy of the registered mortgage document. It works really well when you're prospecting for buyers that have specific needs and wants. Application received and application entered, you get what's called a pending registration. And we pay out and complete based on pending registration, but it typically takes a day for the official records to be amended at the land title office. So quite often you'll see the application received on one day, which will be your completion date in most cases. And then the application entered really is just for public record. It's exceedingly rare nowadays that anything gets bounced back. They to give it a pending registration number, the land title office is saying they vetted it and it's accurate and it's good, and we'll update the records, is basically how that works. Then we get into registered owner. This one's fairly simple. It's straightforward. We'll get into some others that aren't. Legal description. Fairly straightforward on this. Legal notation. This certificate may be affected by the Agricultural Land Commission Act. That's something that you'll find in there. You'll find PPSA agreements. Sometimes I've got a sample of one I'll show you that can be registered, and that can sometimes give you pause to think what could be connected to it. I've seen them in cases of multi-tenanted buildings, and the bank puts a personal property register against all the chattels, like the fridges and stoves and all the things that come with the building, and it can lead to a PPSA notification under legal notations. We'll get into that a bit more. There are no legal notations interest in this one. Duplicate indefeasible title. And that was what I wanted to say is kind of an exception to that snapshot rule. A duplicate indefeasible title. Can anybody tell me what duplicate indefeasible title is and what restrictions it puts on a property?
This was in the real estate training book.
Pretty sure it's the original title is locked up in a safe box or something like that, like the
Or
original.
it's been
Close.
issued to somebody
To
else to
somebody.
hold as collateral. Sometimes the
Yeah.
bank will have it, sometimes the
Yeah.
lawyer will still have it.
Yeah.
But they're holding a copy of it for a purpose.
Yes, Janet nailed it. Did you hear that?
Yeah, that was excellent. It used to be very common. It's not very
They're
common any-
leprechauns now.
Yeah, it's not very common anymore, but we still run into situations where duplicate title has been issued, and if it's lost, it can mean months, and I mean months, and thousands of dollars to get it replaced in the land title office. There's advertising, there's a whole rigmarole you have to go through. So if you are taking a listing or do a title search and you see that the indefeasible title is out, that's something you don't want to wait till after subjects are removed to deal with. You want to get on that straight away and get after it, because a lot of times what we're finding the problems are nowadays is a lawyer had it as security, and now they've gone completely electronic, and oops, it got destroyed in the old records. And banks, same thing. They discard them, and or a law firm that was Jane, Joe, and Bob, and then they've all split, and that law firm is morphed into 3 other versions, and nobody knows what records were where. So duplicate titles is something to be very wary of. Any questions on duplicate titles?
Do we do it? There is one.
Just call the lawyer
And
and tell me. Eden says, what do we do? Says,
Yeah,
get them to talk to their lawyer.
Phone your managing broker right away. They'll, if you get stuck, but talk to the lawyer for the client. And it's not as common anymore, but some older generation just like to have it because they figured that that's their title, and they have it in a safety deposit box. I found people that had it in a file on top of the fridge, and it's wacky. And what it does is it doesn't allow you to do anything with the property. So it freezes it. You can't put on a mortgage. You can't transfer the property. You can't do anything if the duplicate title's out.
And what if you never find it? What happens
That-
then?
Yeah, so if you
that's-
never find it, you have to go through the advertising and the applications to, yeah.
Okay.
And it's a long drawn out affair. It's something that you have a family that wants to move in a month. It's not going to happen.
Yes.
And just for context, I mean, it's good to check, but I think at this brokerage, I've seen 2 or 3 out of a couple thousand files a year. Is that around what you've seen at the other brokerages too?
Yeah, they're few and far between, but when they rear their heads, they're typically pretty ugly.
It's interesting, because I was just looking at a property where the lawyer had pulled one and it was dated that it had been done within the month. So I
Oh.
questioned the agent and I'm like, why is there
Why?
a duplicate title just given to?
Yeah.
And she said she couldn't answer the question, but she did confirm the lawyer still has it
Okay.
and we'll deal with it. And I thought, well, that's weird. I mean, it was just. a listing of-
Sometimes they'll be used as, if somebody's getting bridge financing, instead of going to the full extent of doing a mortgage for bridge financing, they'll give the duplicate title as essentially collateral
Okay.
until the
So, and then
transaction's
if
complete.
if it's out, Brad, and in Janet's situation, the lawyer is like, yeah, no, we have it. Does an additional subject clause, would that call for an additional subject clause that infeasible title must be deposited in before such and such date?
No, that's on the seller, but I would want written confirmation from them that they have it and they're able to return it to the land
And-
title office.
Not in the contract.
No, it doesn't need to be in the contract. You're not gonna hurt anything by putting it in, but it's they.
Like maybe a term.
Yeah, the contract itself says you're gonna provide
Free and clear.
title, free and clear. So the wording of the contract covers it off in effect, but it's way better. It's just like GST. It's better to bring it out in the open and deal with it, and so everybody's on the same page. Awesome. Okay, we've got a strata title here. So same things apply, the title numbers and everything at the beginning. We've got the registered owners. And these ones are joint tenants. I know everybody knows, but somebody amuse me and tell me what joint tenants is.
They own it together and one can,
Die.
well, one dies. I just had this situation. One dies, the other one assumes the ownership.
It's right of survivorship. Yeah,
Yeah, they're
So-
free to sell.
yeah. So it automatically conveys to the survivor. There's no, you simply take a death certificate to the a certified duplicate of the death certificate to land title office, and they'll transfer it into the surviving person's name. What is a title if it doesn't say joint tenants or tenants in common on the title and it's silent? What does that mean?
Isn't that it's joint tenants?
Does it revert to joint
I think
tenants?
It assumes tenants in common, doesn't it? Unless it's specifically
Yes.
stated as joint.
Yes, so that is a trick. If it's silent, it's tenants in common. And that's something to absolutely be aware of, because we have had titles with elderly people that didn't have joint tenants or tenants in common on it. And they just assumed the survivor would get it, and it ended up having to go through the estate. So joint tenancy is a tricky one. Well, it's not tricky, it's just something that you really need to be aware of. Just checking my notes here. Okay. I'll have more on that in a little bit, but we'll go down to description of land. It's got a whole big long write up there for legal description. What are you supposed to have included in the legal description in your contract of purchase and sale?
All of it.
Ashley says all of it.
Okay, anybody else?
I thought you could stop after the plan.
Yes, that's correct. You do not have to put together with an interest in the common property, that bit. Everything else is required.
Brokerage we had.
Yes.
Our last brokerage told us we could not do that.
Yeah.
Good to know.
Yeah, it has no legal weight that together with an interest in the common property, as far as the legal description goes. The PID is the most important part of the legal description. It is the most exact way we have to identify a piece of land in British Columbia. And then we have a bunch of legal notations on this one. We've got permits, municipal permits, and these are all things that can have, and I'll get into in the summary, have effects on the use of the property. And so we really should be getting legal opinions for our clients as to the ramifications some of these things might have. We had a situation a long time ago. Heidi Lucy, who is with us in the Vernon office, had a legal notation on a piece of property that actually had an old, it was like a right of way, but it was under legal notations, and it turned out that the strip of land right down the middle of a piece of property wasn't actually their land, and we had to get surveyors involved and everything else, and this thing dated back to like 1936 and all that. So there are hidden things in some of these restrictions, and that you need to be a little bit of a detective and don't just assume that everything disappears and is of no consequence. Mortgage, that's where you can get them, you can search the mortgage number and you can actually get a copy of the mortgage from Form B. That can be helpful. In this case, there's no duplicate titles or transfers or applications. And so we'll move on from that one. Okay, this one's fun. As fun as titles can be. We have a situation where we've got undivided interest and we have joint tenancy. So you can break up the ownership of the property in any multitude of ways. So in this case, the 1/100th interest is as joint tenants. So those two people have right of survivorship as to their 1/100th interest. But that is not joint tenancy with
See
the
screen, that light's off. You want to shut the light off? Yeah.
It does not extend to the person who has the 99/100. So it's
So sorry, can you say that again, Brad?
the joint tenancy does not extend to the person with the 99/100th interest. It's silent in that regard. So it reverts to tenants in common between the first registered owner and the second registered owner.
So does that mean if Juniper dies, Levi gets the property, but if Levi, or the other way around?
No, if Juniper passes, then Stephen gets the property or vice versa.
Oh,
But if Levi passes, it becomes part of the estate, or if one or both of the other ones passes, it becomes part of the estate.
I see. Yeah, I didn't see the two names. Yeah.
Yeah, so the joint tenants only is specific to that interest. And you see this quite a bit on situations where parents or grandparents are helping kids buy property and they want to have the 1/100 so that they can, for tax purposes and property taxes and all that kind of thing, they will do it that way. We have talked about mortgages on rental properties. We also see a lot of assignment of rents. I don't have a title with one on it, but can anybody tell me what an assignment of rents is?
If they default on their mortgage, then the rent payments will go directly to paying their mortgage.
If they
Yes.
default, yeah.
The
It's
bank
the renters.
the bank has the right to go directly to the tenant and insist that the payments be made directly to them.
Next one.
Okay. Yeah. I think we're
Okay.
good.
Because that's on, isn't that on all Silver Star titles, assignments of rents?
Yes, it's fairly standard up there.
Doug? Who owns that Silver Star? Nope. It is right on all Silver Star stuff.
Yes.
Yeah.
Okay, and any that are part of the resort association umbrella
Okay.
that have a contract with Silver Star.
Yeah, like the
for
out
management.
and like the outback and stuff, right? Like
Yeah,
anything with
exactly.
like an interest. Yeah. Okay.
Yeah. Okay, next one. Ben Trainer. So we've got joint tenancy, it's fairly straightforward. Strata lot, we don't need the part about the together with an interest. There's something called an annexed easement. First of all, can somebody tell me what an easement is? Nobody?
Google.
Isn't it when somebody else has a right to use a portion of your property for their purposes, like a driveway where you have to cut across somebody else's property to be able to access your own?
It's to the
Besides-
benefit, yeah, it's to the benefit of one party over another party.
Yeah.
Benefit of
That's
one
right.
party over another. Yeah.
So what's an annexed easement?
Something that's
The
next to
city.
it.
Like in use of easement.
Okay, an easement is a charge on your property that gives somebody else the right for use, access, egress. They can be for different purposes, but it gives you a right over the subject property. Annexed easement is for the benefit of that property over another property. So an annexed easement might be, I have, my driveway goes over the corner of my neighbor's lot. And so there's an easement registered on his title, and an annexed easement is registered on mine because it's for the benefit of my lot.
Makes sense.
Does that make sense?
Yep.
So annexed easement is normally a good thing when you're looking at a subject property. You just need to make sure that it covers what the use is. There are annexed easements that go back, especially in rural properties, that were purely for driving, for example, cattle across somebody else's property. And then everybody forgets and they go, there's an easement there. And lo and behold, they want to use it as a driveway, but it wasn't a permitted use. It was only for driving cattle back and forth. So you have to be a bit of a detective and read it. Just don't go, oh yeah, it's an annexed easement and it's all good. There could be things, roadblocks that could come out of it. But generally speaking, the annexed easement is a good thing. Undersurface rights. Can anybody explain undersurface rights to me?
There's some type of mineral.
Take a wild guess.
Mineral rights or gold or oil.
Yeah,
Anything
undersurface
that's
rights.
under the ground.
Yeah, we don't, our freehold interest in land does not extend to the minerals and things beneath it. And they can actually be separated. Those rights can be separated from the freehold transfer and sold and bought separately and everything else. It's not hugely common, but we've had a few in Vernon, especially gravel pits are one that comes to mind right away that we've dealt with several in the last year actually. And so you have to be very careful under surface rights because somebody might have a beautiful 10-acre property and they want to build their dream house on it and something else. And somebody else could theoretically own the rights to what's under the ground and have the legal ability to access it. And that could totally blow apart the person's intended use of the property. Right away is fairly self-explanatory, mortgage.
So,
Okay.
sorry, Brad, just to go back to the undersurface rights. So is it red flag when it's like registered to somebody else? Because a lot of
Yes.
them are just the queen or the crown.
Yes, but you have to pull the document because the crown normally has given that right to somebody else.
Is over there, they're all to her.
So you have to follow the paper trail. So it is definitely a red flag to double check if there's undersurface right. And who can tell me what inter alia means? You can
It's on a
have
bunch of other titles.
yeah. So inter alia can be a mortgage, it can be a right of way, or easement, covenant. It means that it affects more than just that one legal description.
So somebody's asking if with undersurface rights, can Robert Davidson come to Glen and June's and start digging?
There's a lot of legislation and things in there. It's not quite as simple as that, but in extreme circumstances, there is case law where people, it's mostly on large tracts of land, that somebody has come in and they assume that they owned everything, and lo and behold, they didn't own the rights to the gravel, for example, and somebody had the ability to come in and mine the gravel.
Gravel's considered an undersurface right as well.
When it comes to undersurface rights, just send them to the lawyer first thing.
That's good advice.
Yeah, we're not, that's not our expertise. Okay. We have lots of, unfortunately, wills and estate type things that come along, estate sales and that. So this is a picture of a title where the executors have been registered on title. So you have James and Jean, executors of the will of Carolyn, and so on. What do you use when you're doing your listing contract, for example, or your CPS? What do you put as the seller?
Estate of James and Jean and their names.
No, it's state of,
Estate.
oh, yes, yeah.
No, it's the estate of James and
Yep.
Jean, isn't it?
Yep.
'Cause-
Yep.
Right, isn't it? But look, it says.
I would say it's actually in James and Jean, and then below that you should note executors of Carolyn Brown Smith.
Well, that's 2 gold stars for Tracy. You actually would put James McCallum, Jean Rochelle Cruz, executors of the will of Carolyn Brown Smith.
And same on the listing contract and CPS.
Yes, that's exactly how it should be. You don't have to put the deceased and C number. You don't have to put that, but everything else is exactly the way Tracy described it.
And then I don't know, you might have an example of this, but then when the executors are not on title and you just have dead mom and the executor with like the will.
And it still needs to be subject to probate.
Subject to probate, but then when you're listing the property, then you're putting
Power of attorney.
an executor.
Yes, that's exactly right. Actually, next slide will help lead into that. This is a sample of a death certificate. And that is part of what you need in order to facilitate it. And we'll just skip through that to the next one. This is really what we're looking for. We're looking for the lawyer handling the estate to say that the people that we're dealing with have been made the executors. The courts have recognized them as executors of the estate. So a lot of times people jump the gun and somebody's elderly parent passes away and they're the executor, but the court hasn't recognized them as an executor yet. It hasn't been registered. And we get all anxious and it's not a big deal, but we're getting things listed and they haven't had the authorization invested in them yet by the court to sign on behalf of the estate. So this is the this is the kind of paper trail we're looking for, is authorization from the lawyer for the estate that so-and-so has the authority to bind the estate. Sorry.
Doug?
Yeah, Brad, it's not enough that's in the will.
It is a good start, and that's normally normally you can proceed cautiously with that, but somebody can contest the will and say, I don't want my stepmother to be the executor of my dad's estate, and they can make an application to court to have the executorship set aside. That's rare and not often done, but technically that is a possibility.
Okay.
But I think generally speaking, if you have a list of these things that are coming in due course and everything stays on time, you can engage in dialogue with the person who's named in the will. Does that make sense?
Mhm.
Okay. One thing that I didn't touch on is everything on the title as far as financial and non-financial charges is chronological, and they take priority in the order in which they are on title. So you'll see that mortgages always come after the covenants and right-of-ways and so on. And if they don't, there'll be something called a priority agreement, which is signed off, and it's, let's say I had a property and I had a mortgage on it, and then I subdivided the property, and a new covenant had to be registered against both titles. That covenant needs to rank in priority to the mortgage. So part of the restriction, or part of what would make that subdivision go through, is I would have to have my mortgage company sign that priority agreement saying they agree that the covenant ranks in priority to the mortgage. So that's how you can tell what's a first mortgage and what's a second mortgage, for example. The first one you come to is the first mortgage, and the second one is second mortgage, unless there's a priority agreement that stipulates that the second one, that the first one flips their spot with the other one. Sorry, I'm not describing that very well. It's just, it's kind of intricate, but it's important to be mindful of the fact that they're chronological. Does anybody have any questions about priority agreements?
Nope.
Okay, awesome. Encumbrances are claims, restrictions, or interest in the property that may affect the owner's right. Common encumbrances include mortgages, obviously, liens, and liens can be builder's liens. They can be liens for any number of things, easements, covenants, leases. Mortgages are obviously loans secured by the property. And we just went over how they rank in priority. Liens are legal claims on the property due to unpaid debts, taxes, or judgments. And we will see liens such as tax sales, you'll see on occasion, different things like that that come on, and they have to be resolved before the property is transferred.
So if the CRA is on there, then you can still have the agreement that that would be paid out for the mortgage.
Yeah.
even
So
though it's
yeah.
later on the title.
Yeah,
No,
it's
it
just-
depends. Well, it depends which order they're in. Like CRA wouldn't be paid out potentially first. The mortgage would be paid out and then CRA. Is that what you're asking?
Yeah.
Which order everything would be paid out?
Yeah, CRA has some special powers that be, but generally speaking, that's right. As CRA, they would have a judgment normally on title. And everything would be frozen and have to go through them.
Same, that would apply to family too, would it not? Some of the Supreme Court family acts.
Family,
Yes.
what about Family Act? Same thing, potentially?
Yes. The mortgage companies are generally held in priority, and then the judgments come in after that. The judgments, like if I have a debt to Michelle, I can't register a charge and then CRA come after me and me get it before CRA. They're gonna jump the line. And there's legislation surrounding that and everything else, but generally speaking, it is the order of which it's registered.
What happens, this might be a silly question, but what happens if there's more owing on the property than what the property's selling for? And the sellers, like, what happens if they can't pay the remaining amount owing?
Yeah, then the sellers are in breach of the contract by not giving clear title.
Yeah,
And if they can't clear title. Right, so Eden's asking if there's like a surplus of stuff owing mortgages, judgments totaling $700,000, and they accept an offer for $600,000.
And the lawyers are gonna have to agree on a settlement, or the court will order something. You'll see a lot of second mortgage companies, for example, buying out the first mortgage if there's a default. And the reason for that is, if the first mortgage company goes and gets a judgment, they're only worried about getting their money back, and they have no obligation to the second mortgage holder. So if there's a shortfall, the second guy can actually get foreclosed off title. In other words, their mortgage is no good because all the money is used up before it gets to them. So quite often, and we'll see more of this in the coming years with the interest rates being what they are, and that the second mortgage company will step up and buy out the first mortgage so that they can control the sale and the amount that will be. I mean, the court ultimately has to say what's acceptable, but they can control what it sells for. Make sense?
Yep.
Awesome. Easements, just remember they can
Yeah.
affect the
So,
owner's use of the land. Next slide is annexed easements. We've dealt with that, so we can carry on. Covenants, they're rules and regulations placed on a property by previous owners or by the homeowners association. They may restrict what can be done with the property. That can be things like no RVs in the driveway, or different restrictions that can affect the use of the property. And they're particularly problematic, or can be problematic, when you have a older subdivision that the developer's long gone and everything's sold and that one lot never got developed. You might be adhering to what is old rules and regulations, and there's really nobody there to enforce it, but you get caught in no man's land because you've got something on title that says you can't do something, even though it now makes sense to do it. So covenants should be reviewed thoroughly and referred to a lawyer if there's any wonder about what's enforceable and what's not.
I think, sorry, Brad, I think you're referring, one of the references would be to building schemes, correct?
Yes.
Yeah. My understanding with building schemes is that even though the developer's long gone, they could the building scheme could still technically be enforced by a neighbor, a member of the subdivision, on anything you do on your property, potentially.
That's right. A group of neighbors could get together and say, we disagree and we have this thing in place, and we're willing to go to court to enforce it.
So even though the developer's long gone, it's still potentially enforceable.
Yes, but not in all cases. That's where I'm saying you have to get the lawyers involved to clear it. So old covenants can be they should, I wouldn't say a red flag, but they're definitely a yellow flag. You should be cautious. If the property is subject to a lease, it may affect the buyer's rights and obligations regarding the property. Most leases over 3 years are registered on title. That's predominantly a commercial thing, but you need to be aware that leases can tie up the property and affect the saleability. Legal notations. A title search may reveal various legal notations and issues that can affect the property's titles. These can include, but not be limited to, pending legal actions, probate or state, applicable legislation. Applicable legislation can be the Land Tax Deferment Act, for example. I've seen title searches that I referred to it earlier on in my conversation that have a PPSA requirement. And the PPSA often indicates that there's a manufactured home or something on the property that is on owned land. And there's a charge against that chattel. So you may have to, it's like, it's not registered, a mortgage isn't registered, but there's a charge attached to that, probably in the manufactured, in the personal property registry, that will have to be paid out like a mortgage. So that's one to be very wary of. Certificate of pending litigation just outlines ongoing or legal proceedings that the property is being pulled into. If property is part of an estate, it has gone through probate, this can affect the title, ensuring proper estate transfers. And we went through that paperwork of what you're looking for. Things like that, don't rely solely on the legal notations. Things like the Agricultural Land Conservation Act, they have websites to go to verify everything. So they should be red flags, legal notations, but often it's the start of searching the ramifications as opposed to coming up with an answer. It normally indicates something that needs to be followed up on. And you have to take it with a grain of salt because it says may be affected, it may not be affected. So that's where you need to go and get the maps and everything else and do your due diligence. Best practices. This is huge. We've had a number of lawsuits over the years that have dealt with this for properties on major roads and all highways. Contact the Ministry of Transportation and Infrastructure in the regional district, see if they have any pending or future plans to grab or add some of the subject property and or cut off non-registered access. We have a number that have been affected by the pipeline out of the Kamloops office. People have roads that have been, they've claimed part of the person's front yard to make the road safer, wider, and different things like that. So you really, anytime you're on a major artery, make sure that you're dealing with access. There is no such thing as a title that is issued by LTSA, only snapshots of the title in the form of title search prints, stated title certificates. And they have no legal consequence. If you tear up a stated title certificate or a title search print, it doesn't have any legal weight. It's just a piece of paper with information on it. Except for a duplicate title, which we've gone over, and that can have significant consequences. I can't stress enough, always deal with current title searches. I know I'm repeating myself ad nauseum, but it's a snapshot on a given date and time, and that can change anytime. So you should always be dealing with current title search, even if you had it listed this fall and you take it off the market for a few months and you're going to relist it in the spring, do a new title search. If you have any questions, get advice from your managing broker, and don't hesitate on a lot of these non-financial things in particular to send your client out for legal advice.
Brad, quick question on currently title search. What's your opinion on current? So if we're on the buy end and we see that a listing agent has a title search that's 3-4 months out, what's standard practice on current?
I'd get a new one. I think probably there's no hard and fast rule, but I think if it's between 60 and 90 days old, you should probably be looking at a new one.
Okay.
Any questions? Is this at all helpful? It's kind of a shotgun approach to a very wide range of topics.
Lots of people shaking their heads. Yes.
Okay, it's my first crack at presenting this one this way. So I would welcome any feedback. If you want to send me an email or things that I could have expanded on more or done differently, I'd love the feedback. And we'll try to get more people through this. I think having a better understanding of titles and the tricks and everything else, it makes you a more astute realtor and more value to your client.
One question Rebecca has.
Yesterday, I forget the gal's name, but she wanted to ask about if there's 10-page titles, and Stacey, yes, thank you. Like how prudent is it to pull each one of those charges and go over everything when it's not a 2 to 3 page title?
Yeah, when there's like pages and pages of.
Yeah, what I normally encourage people to do in that time is normally the lawyers are going to pull them anyway as part of the conveyancing. Everything else, I would try and partner with them and work, get the lawyer involved earlier on if they're going to be the conveyancer, and get the lawyer to pull them and go through them.
Okay.
Because some lawyers' offices keep databases like
Yeah.
they do, and they may already have them on file, right?
Yeah. Yeah.
Don't
So search our
forget the
database.
vault.
Yeah, the vault. Yes.
Yeah,
A lot of the
absolutely.
subdivisions we've already dealt with, so we could have a lot of documents that way. Also, if you have access to the developer's disclosure statement for subdivision, sometimes that can provide at least insight for you if there's anything you really need to be aware of.
Yeah.
And Brad, we
the
can
one
send
thing,
out.
sorry.
Go ahead. You go.
The one thing to remember is that we're not lawyers, and it's not up to us to interpret and tell people the ramifications of these charges and what have you. It's our job to raise the red flag, yellow flag, whatever the case might be, to say we need more information about this. And we're kind of the quarterback that puts things on the radar that are important, but it's not for us to have to know the answer to everything. We have to know to ask the question. That's our role.
And I mean, I really like the lawyer thing, but Brad, you and I have done this before with that Kamloops office. We can send out that information what's that office called? Abstract Registry?
Yeah, they're great.
Yeah. So in Kamloops, you send them the title and they pull everything, or you can send them stuff that you've pulled so they don't charge you, and they mark up everything and sort of red flag, and they put little red notes next to things. And like I did one that was on a lakefront lot and had a whole lot of acreage and had a lot of weird stuff. And it was about, I think it was like $300 for them to mark it up. But certainly if somebody
quite honestly, they're more knowledgeable than 95% of the lawyers. They're specialists in what they do, and it's a very worthwhile investment.
So I'll send that info out to you guys.
Terrific.
Anything else? We're exactly on time, 12:02. Good job, Brad Marsh.
Good. I have a Zoom meeting starting 2 minutes ago, so I'm going to bid
Okay,
you all
perfect.
adios, and we'll catch up soon.
Thanks, Brad.
Take care, everybody.
Bye.
Thank you.